Now bring the Board of Appeals meeting into order. Before we get started, I'm going to throw out there because it just came to my attention, someone told me that it was going around Facebook that this was going to be a commissioners meeting tonight. So just so that everyone understands, this is a Board of Appeals meeting tonight, not a Board of Commissioners. And if any of you came in late, not sure if you did or not, but if you weren't able to sign up in the sign-up sheets on the back, you will not be able to speak tonight. So with that, we're going to stand for the invocation and the Pledge of Allegiance.
Let's pray. Dear Father, we thank you for the time that we have together tonight. I just ask, Lord, that you would give us wisdom as we hear over these cases tonight, that you would allow us to make the right decisions and the best decisions. I pray that you would have everything done decently and in order, that you would protect our county, that you would watch over us and strengthen us. In Jesus' name, amen.
Now, if you follow me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, so before we move into new business, Ms. Dial is going to read the thank you. It's going to read the rules of citizen comment that will preside over everyone's comments tonight.
Speakers must sign up prior to the meeting and provide their name, addresses, and the topics they wish to discuss. Speakers must direct your remarks to the board and not to individual commissioners or to the audience. Personal disagreements with individual commissioners or county employees are not a matter of public concern, and personal attacks will not be tolerated. The chairman has the right to limit your comments in the interest of disposing of the county's business in an efficient and respectable manner. Speakers will be allotted 3 minutes to speak on their chosen topics as they relate to the matters pertinent to the jurisdiction of the board. No questions will be asked by any of the commissioners during citizens' comments. Outbursts from the audience will not be tolerated. Common courtesy and civility are expected at all times during the meeting, and no speaker will be permitted to speak more than 3 minutes or more than once unless the board votes to suspend this rule.
Okay. So moving into new business, Mr. Allen, you kick us off.
Okay, first hearing tonight, first agenda item is variance application 25-18V. Harry and Jeanette Fox, owner, 326 Malloy Road, parcel 268-02023, located in land lot 19 of the second land district, is requesting reduction of the minimum required roof pitch from 412 to 212 on a replacement mobile home. Property contains 5.17 acres.
Okay, so before we need to have a motion to open public hearing.
Make a motion, open public hearing.
The second? Second. Okay. All in favor, raised hand. All yes, no, all agree. Okay, so with that, do we have anyone?
Yes,
Line
Mr.
to
Chairman,
speak.
we have Pastor Katie Pash. Could you
Sure.
please come to the front and state your name and address, please? Yes, ma'am.
And if
Pastor
you could
Katie Pash.
pull this down to where everyone can hear you.
All right, thank you. Pastor Katie Pash. I live at 1632 Middlebrooks Road, Griffin, Georgia. And I filled out the application for Mr. Fox. I represent the Long-Term Recovery Committee from the disaster of the tornadoes in 2023. I didn't know if I needed to speak, but thank you for hearing this case.
Anyone else? Is that it?
No one else has signed up.
Okay, that's all the speakers we have, so we can close. Do we have?
Is there anyone to speak against it, or is that the only person, Erica, that signed up?
That's all we
That's
have.
the only one, Mr.
Okay,
Galloway.
thank you. Just
All right, do
check.
we have a motion to close the open session for this?
Make a motion to close.
Second?
Second.
All in favor, raised hand. All approve? Okay, so now, we need to discuss, but before we discuss, we need to have a motion.
You need to have the staff report first.
Now we'll have the staff report by Mr.
Okay,
Allen.
so this is a application that's been around for a few months. Staff has been working with the gentleman, who is a disabled veteran, and like, Ms. Pash said, his home was damaged during the tornado, outbreak about 2 years ago. So we've been working with him on all the different details of bringing in the replacement mobile home. So basically, the only requirement he does not meet is that roof pitch. Staff does not have a problem with this. I think time is kind of the essence with getting him back and steady in his home again. So staff does recommend approval of this, and there are several approval conditions for it related to the finishing the construction of the home at the end, should the board choose to approve this.
Does that complete the staff report?
Let him go ahead and read the conditions so you'll know what you're voting on.
You scroll down just a little bit more, Eva. All right, approval with following minimum conditions. Building permits are to be finalized within 15 days from the approval of the variance. I think that's doable. 2 other Class A manufactured homes, not Homer, requirements set forth by Section 203 will have to be met before the issuance of a certificate of occupancy. And that involves footings and then a 3-foot by 3-foot porch on the front and back of the house. Number 3, the Environmental Health Department shall issue any necessary well or septic system permits. And number 4, all building setbacks shall be met. We've kind of already measured the setbacks, and that does not appear to be a problem there.
That conclude?
Yes.
Okay, so we need a motion to take action on this.
I'll make a motion to approve with the staff recommendation.
Okay, do I have a second?
Second.
And do we have discussion? Okay, any discussion?
So this is a new mobile home, complete.
Yes, sir,
So
to
there's
replace what was damaged, yes, sir.
So that doesn't, because I know there's certain requirements for having a mobile home in Spalding County, but since it's replacing an existing mobile home, there's no other issues that would come up.
It has to be a Class A, but as I said in the staff report, in terms of the size, the width, and all those, he meets those, just not the roof pitch slope.
I do have some questions. So just out of curiosity, where has the gentleman been living for a year plus? Can you hear me?
You
Is the
need to
gentleman-
bring Reverend Pash back up if she's gonna answer questions.
You can answer for him if,
Okay.
Yes, ma'am, if you'll just come so we can record you in the mic.
He's been living in the mobile home that is destroyed.
Ah,
He's-
okay.
The back part of it, a tree fell on it, and so he's been living there. All this time, as many people still are living in their homes that were destroyed by the tornadoes.
okay, all right.
The mobile home that we brought in was donated by a movie company. And I think we've fulfilled all those other requirements.
Yeah. Okay. So the new mobile home is currently on the lot with the old mobile home.
Yes,
So I
The-
guess if we can, I'd like to make a condition that this original mobile home has to be removed, maybe by a certain timeline. I don't want to extend his ability to be able to move into the new one, but I would not like to see 2 remain on the property.
the current mobile home is way in the back of the property, and this one is right by the road. And we're a nonprofit, we're helping him, and we have $56,000 left
Right.
to do our work.
And I did, while we're on that topic, and this is for the county, the public in general, because I've seen this happen. I think this is the third time I've seen this, where a mobile home has been moved onto a piece of property without a permit being obtained first. And as a county, and I'm not addressing you specifically, ma'am, but as a county, we've got to manage that, and the decisions we make have to be positive for the entire community. So I just want to put that comment out there just for the public, and, yeah. So the condition that I'm placing on this application, that has to be approved by the board members.
Okay,
Is
you
that-
need, Mr. Chairman, you need Mr. Smith to accept that as an amendment to his motion, and Ms. Cord will need to accept that as an amendment to her second.
So what kind of timeline do you want to put on that?
What would you suggest, Mr. Allen?
At least 6 months
Yeah.
due to the circumstances. Is that,
I think we can do that, yes,
Okay.
sir.
I know this is a, you know, a kind of a need. I don't want to put anything undue on, you know, on him or on y'all to move that. I do agree with Mr. Slaughter that we probably do need to have that removed. So if 6 months, if you think that sounds reasonable,
You good?
I'll make an amendment, a motion that we amend, or I'll accept your motion, or
Okay.
your amendment. How about that?
All right, is this, Ms. McCord, do you accept that as a second, with your second?
A second.
Okay.
All right, we're at the point for a vote now with the addition. All in favor,
Additions there.
raise hand. Okay, all in favor, none opposed, 4-0.
so the variance is approved, and I'll get with you over the next several days to determine what's left to do physically, and we'll get this finished up.
Okay, thank you
Thank you,
very
ma'am,
much.
thank you for
Appreciate
your
it.
efforts.
Thank y'all for helping.
Okay, moving along to item number 2.
Okay, variance application 25-19V, Hugo Alvarez, owner, 15 South Road, parcel 268A01054, located in land lot 14 of the second land district, is requesting a reduction of a front setback from 100 feet to 50 feet. The property contains 0.5 acres.
At this point, we need a motion to open the public hearing.
I'll make a motion to open public hearing.
Okay, do we have a second?
Second.
Okay,
Mr. Chairman, nobody has signed up for this application to speak.
so we didn't vote on that. All in favor to, Mr. Park? We're voting to open the public. Okay.
Yes.
All in agreement to open the public, so,
Was it,
well, I guess
There's no
we
one
should.
signed up to
No
speak?
one signed
Is
up.
the
Yes, we'll close
applicant
it.
here?
is the applicant is here?
Okay, all right.
Would you like to allow the applicant the opportunity to sign up so that he can speak to
Well,
the
I
application?
think he was here before, and I told everybody that was here to sign up beforehand, so. So at this point, we need
Close
a,
it.
yeah, motion to
Need a
close.
motion to close.
In a second? Need a second? Okay, all in favor to close? All in agreement, none opposed? Okay, Alan?
Okay, so this is a lot, similar to one that was approved on West Road last year. And, I forget the name of the subdivision, but it's a very old subdivision. West Road, South Road, and a couple other roads that form the subdivision from many decades ago. The lots all basically contain roughly half an acre. This one is no exception. They're all pretty much shaped like squares. Back in the day, that was probably adequate, but with modern setbacks for the lots, the 100-foot front setback for this one and the next one, 23 South Road, are pretty restrictive due to the it being a square and not being a super deep lot, it would be very restrictive on putting an adequate sized house on the property. So the applicant is seeking relief from that front setback from 100 feet to 50 feet. Most of the houses in the area that are already out there, I can't think of one that's at 100 feet. Some of them are at like 60, 50, in that range out there already. So this would kind of go along with what's out there already.
So at this point, we need a motion to move on this item.
Are there any conditions, David, on the approval? Or the recommendation?
Just a reminder that all other AR1 requirements need to be met.
Do we have a motion on this item?
I will make a motion to approve.
Need a second?
Second.
Okay, all in favor?
the
All right,
second.
raised hand. No. Back up. So we just, okay, so we made the motion to, we have to discuss it first.
Up to you.
Okay, sorry. So do we have a discussion on this before you actually vote on approving? Okay, so I do have some questions. What's the current zoning in that area for this?
AR1.
And what's the required size lot for an AR1?
Well, if you were to make a new one today, it'd be 3 acres. However, these are from like the 60s and the 70s, before there was even a zoning code.
Yeah. This is a tough one for me because, let me speak into the mic. This is a tough one for me because this is located on the future development map. It should be, these areas should be low density, single family residence, minimum size lot, 1 acre. This is to preserve open space and rural quality of life. So understand that the lots were made, that they're legacy lots, like 30, 40 years old. But still, it doesn't conform to what Spalding County is trying to do with our curb appeal and with our growth. And currently, just kind of looking at the map, there are 37 additional lots in that area. And, if we approve, and we have four tonight, and if we approve these 4 for the 50-foot setback, then we're setting a precedent for that neighborhood, for those small lots. And plus, is there water in that area, county water?
There,
I believe there's county water, but not sewer.
right.
So no sewer. So speaking with the water for the health department, they have to have 2 locations, a primary and a secondary septic system site for the lots. So they have to put a house, 2 septic sites, a driveway. They're minimum size lots at this point, and we've got several more that we're gonna have to deal with. So the point comes, I personally, I'm gonna have to decline it because I want the county to move forward in a more positive direction. We're trying to make a change in the county to better ourselves. And I think that if by agreeing to these, we're just gonna be kind of doing the same thing we've always done and kind of set ourselves back. So anyway, that's my point.
Mr. Lawler, could I address that briefly? And I understand everything you said and every concern you raised. The problem we have with all of these lots that are on the agenda tonight is they are pre-existing lots of record that predate the zoning ordinance and predate any restrictions that Spalding County had, because Spalding County didn't have a zoning ordinance until 1962. And these lots go back, I believe this area is referred to as Kendalltown. And these lots go back to the 40s. So there are development rights that attach to these lots, even though exactly as you said, They are small and could not be approved today, but they are pre-existing lots of record. I didn't mean to.
No.
I didn't mean to rain on the
It's
parade here.
discussion. It's
That's,
discussion. It's discussion.
And I can appreciate what you're saying too, but correct me if I'm wrong, most of these lots are already built on in this area too, correct? I mean,
There's a lot of open lots there.
Yeah, I'd say maybe a little less than half are developed.
I guess my point is, it's, it's undeveloped enough that it could move forward in a positive direction to provide Spalding County residents with a nice atmosphere and climate for the neighborhood. But, it's kind of moot point because, it can be built on anyway. As far as the 50 feet, yeah, I guess, I'm done with my comments. Any other comments?
make a motion to close? Do we need a motion to close?
No, we've got to vote now.
Y'all have already closed your hearing.
Okay, so all in favor, raised hand. All opposed, like sign. 3 approved, 1 opposed. Okay. So that finishes that one up, and we'll move on to item number 3, Mr. Allen.
Okay, variance application 25-20V, Hugo Alvarez owner, 23 South Road, parcel 2688, A01055, located in land lot 14 of the second land district, is requesting reduction of a front setback from 100 feet to 50 feet. Property contains 0.5 acres.
We need a motion to move into open public meeting.
Maybe anybody signed up for this one?
No one has signed up for,
If no one has
This
signed up, do we
application.
have to open it?
Let's go through the process, yes, sir.
Okay, all
Sorry.
right.
Motion to open public hearing?
Second? Okay. All in favor, raised hand. Okay, passes 4-0.
Motion to close public hearing?
Second? Do we have a second?
Second.
Second.
need a second to close?
Okay, all in favor, raised hand. Okay, all in agreement, public meeting is closed. Mr. Allen?
Same exact situation as the last item.
Oh, we can go ahead and vote then. Oh, well, actually, we need a motion. We need a motion on this item. I'm sorry.
You're good. I just didn't want to jump in the middle of anything.
That's good. All right, so we need a motion on this item.
I'll make a motion to approve.
Okay, second.
Second.
Okay, all in favor by raised hand? All opposed? 3 in favor, 1 opposed.
Okay.
Okay, item number, I believe we're on 4 now, correct? Item number 4, Mr. Allen.
Okay, variance application 25-21V, Jamie Williams and Daryl Strickland, owner, 5 Green Road, parcel 268, A01027, located in land lot 14 of the second land district, is requesting reduction of a front setback from 100 feet to 50 feet. Property contains 0.5 acres.
All right, so need a motion to, do we have someone to speak?
Yes.
Okay, we have someone to speak this time. So, all right, need a
I'll make
motion
a
to open the
motion.
public.
Open
Need a
public.
second?
Open for.
All in agreement, raised hand. All in agreement. We are, it is open. And we have a speaker.
Yes, Mr. Chairman, we have one person signed up, Mr. Reginald Williams Senior. If you would come up to the podium and state your name and address, please.
You're just in your mode.
state your name, address, and topic.
My name is Reginald Williams Sr. I stay at 135 Kendall Drive, Griffin, Georgia, 30224. I'm here to discuss with the board about the ordinance, about the two homes you're trying to approve to be built behind my home. I'm recently moved to Griffin. I'm a native Georgia. I'm native from Atlanta. I was born and raised, went to high school there, went to college in Georgia before I joined the military. I suffer from PTSD. I tried to live in Atlanta after I came back from the military, almost 10 years. It didn't work for me because of the close proximity of everybody. And I have too many triggers from my PTSD, so I moved to Griffin for that exact reason, because it's nice and homey. I chose this neighborhood because it's elderly, and because the neighborhood was being redeveloped due to everybody being hit by the tornadoes. I asked when I bought the home, before I bought the home, was anybody going to do anything with the property behind me? I was told it was not. It was going to be it was going to stay farmland. This board has already approved 5 homes, and with this one and these next 2, you'll be approving 2 more. That would significantly increase not only the property taxes of my neighborhood, it could also mess with my PTSD and trigger so many things. And I don't have the money nor the resources to move any further again. So I would ask that the board deny these last 2 claims, at least for me and my family's sake. That's all.
All right, thanks, sir. Fellow veteran, so I understand. Okay, we're at the point to close the open session at this point. Do you need a motion?
Make a motion to
Need a
close.
second? Okay, all in favor of closing the open session, raised hand, all in agreement? Okay, do you have anything further?
So this is, the road to the east of, South Road that we just talked about, 2 parcels, this one and the next one on Green Road. Physically, zoning wise, it's the same situation, same zoning, same half-acre lot, which is a square, which if the houses are to be built, that he needs relief from the front setback of 100 feet.
All right, this time we need a motion on this item. Board. Ms. McCord, Mr. Parks, Mr. Smith, we need a motion on this item, whether to approve or decline.
I'm the owner of this property, and I have something to say.
No, you should have signed up before, sir. I'm sorry. They don't have to sign up? Okay, my mistake. Yes, come forward, please.
Could you make a quick motion to reopen the public hearing?
Okay,
Make a motion to reopen.
second?
I second, reopen.
Okay, all in favor? All right, session is open.
Hi, my name is Jamie Williams. My address 400 Kendall Way, Hampton, Georgia. I bought this property several years ago with the intentions to build. My parents are from this neighborhood. I was born in this neighborhood. My parents still own property in this neighborhood. So after the tornado, it destroyed a lot of properties. Now the neighborhood is being developed. So the last thing I want is that the neighborhood start to decline again. Because as of right now, any empty lots that's there now, people are starting to come out, dump trash, old tires. I mean, and this is happening like every week. So the last thing that I want to see is for our neighborhood to go back into a decline. I mean, you know, I know everybody wants land beside them and all of that, but, you know, unfortunately, out there in our neighborhood, it's a lot of areas out there that we're working on cleaning up now. But, I mean, it's going to become a dumping field if we don't develop some of this land. We want our neighborhood to be a nice neighborhood, you know. So that's all I got to say. I would like y'all to take that into consideration.
All right, thanks, sir. And we have, you speaking, sir?
Yes. So I'm actually the owner of 5 Green Road. He's 7 Green Road. I actually purchased the land from him. I also sold Mr. Williams his house. I redeveloped his house
So
and
do
sold
you,
it to him. The original speaker,
So you're on this application as well, is that?
I am.
Okay.
I am the applicant on
Okay.
Mr. Strickland?
5.
Are you
I'm
Mr.
Torrey Kennedy,
Okay.
yeah.
Yeah.
So it's actually my property, just haven't exchanged, I guess, in the, with the court filing, I suppose, or something like that. It hasn't caught up yet. But, Mr. Williams approached me, the owner of 135, he approached me while I was on the property doing a survey. And he was under the assumption that it was actually his property. I actually sold him his property. So I showed him where his property lines were. So I'm not really sure where these come from. That was never discussed. It was never, he assumed that it belonged to him, and I just explained to him that it didn't. It actually didn't even belong to me at the time that I sold him 135. I actually purchased that additional lot after the fact with an agreement from the owners to assist them in developing that land in that area. That's it.
okay,
So I never heard any discussion about having space or anything like that.
got it. All right, thank you, sir.
Motion to close public hearing.
Second,
Second that.
all in favor, raised hand. All right, public hearing is closed. Okay, do you have anything additional, Mr. Allen? Okay,
Just zoning code wise, this is street over, but the same physical situation as the other two.
all right, this time we need a, motion on this item.
I'm gonna make a motion to approve.
Are there
Need
any
a second.
conditions on it, David?
Just that all other AR1 development standards shall apply to the home, i.e. size, things of that nature.
Which
Need a
applies
second?
anyway, you're okay with it.
Second.
Okay, all in favor, raised hand. All opposed, same. 3 in agreement, 1 opposed. Let's see, I think we're on item number 6, number 5. Okay, Mr. Allen,
All right, variance application 25-22V, Jamie Williams and Daryl Strickland, owner, 7 Green Road, parcel 268A01-028, located in land lot 14 of the second land district, requesting a reduction of the front setback from 100 feet to 50 feet. Property contains 0.5 acres, and this is the gentleman that spoke from Kendall Drive. This is one lot further down than the 5 Green Road you just heard, so.
do we have anybody? Okay, so we have one to speak. Do we have a motion to open public session?
Motion to open.
Second,
Second to open.
all in favor, raised hand. All in agreement, it's approved. We're now in open session.
Mr. Chairman, the first speaker is Torrey Kennedy. Okay. The next speaker to sign up is Reginald Williams Senior.
She just left.
Okay.
Okay,
Mr. Chair, that's all we have signed up for this application.
okay. Do we have a motion?
Close.
Second?
Second that.
Okay, all in favor to close, raised hand. All in favor, approved. Is closed. Have anything further?
Another square.
All right. So at this point, we need a motion to take action on this item.
I'll make a motion to approve.
Need a second?
Second.
Okay, all in favor, raised hand. All opposed, like sign. 3 in favor, 3 approve, 1 opposed.
And as a point of discussion, I would like to say too, and Mr. Allen can correct me if I'm wrong, what we're doing here today does not affect their ability to build on these lots, correct? Like, they can still build on these lots just with the existing requirements. What we're voting on is to approve or not the setback.
Just a setback, yes.
Yeah. So we're not telling them that they can or can't build. They still have to go through the process with the county on everything else to
Yeah,
meet.
there's, every other requirement has to be met. It would just be difficult with the 100-foot front setback to have a big enough buildable area.
Right. But the 50-foot in that area is in line with the other homes in that area. for the
More or
most
less,
part.
yes, as an average.
Okay. So we're not really doing anything that's out of character with that area. That's how I'm looking at it. Anyways, thank you,
Correct.
Mr. Chairman.
Okay, item number 6, Mr. Allen.
All right, variance application 25-25B, Jesse Champion, Jason Reiner, owner, Lamar County Line Road, which is a portion of parcel 228-04002A, located in land lot 249 of the second land district, is requesting reduction in the lot frontage requirement and the allowance of a shared driveway. Property contains 76.32 total acres, but it'll be divided into roughly a 40-acre portion for this property.
We need a motion to move into open public hearing.
Make a motion to open.
Second.
Second.
Okay, all in favor, raised hand. All in agreement, we're in open session at this point.
Mr. Chairman, we have one speaker, Stacy Donaldson.
Good evening, Stacy Donaldson, 1058 Moreland Road, Williamson, Georgia, but it's actually Spalding County. So I'm a resident of Spalding County. I also own a real estate company here in Griffin that we've been in business 26 years, Heritage Realty. Anyway, so I do represent Mr. Champion in this transaction. Mr. Champion actually had a 76-acre tract, so he had a house and some land, and then he has this back 46 acres. So it does have enough road frontage, just 560 or a little more road frontage in the front for the property. It does, however, have a pond, and so there's a driveway on the right side of the pond, and on the left side of the pond, you can take like a buggy or, you know, a side-by-side and drive on the left side of the pond. The whole pond is on this 46 acres. It isn't feasible to put in a driveway on that left-hand side. Just the money, the feasibility of it. So Mr. Rayner wanted to purchase the property and do a shared driveway. So, the other day coming home on Moreland, my son lives on Lakeside and was like, Mom, I need you to stop by my house. So instead of staying straight on Moreland, I go left on Marybrook Road. Well, lo and behold, I look to the right and there's a shared driveway. It was recently done in like 2022. 376 and 378 Marybrook Road. That was actually a 15-acre tract. No, hold on. Let me have my glasses. I'm sorry. That was actually an 18-acre tract that was split, and it only had 250 feet of road frontage, which made both lots, one 3-acre lot, 125 feet of road frontage on the plat, and 125 for the 15-acre, but they're sharing a driveway. So I guess my thought is if they could share a driveway, and I don't understand why this one couldn't have a shared driveway as well. Because it actually, and I've got that, I'd be glad to pass it if I don't know if you can have it or not, but that is the Marybrook. It shows the original plat, it shows the new plat, it also shows some pictures of the shared driveway on it as well. I don't know if that helps or not.
Yeah.
Any questions or anything y'all have for me?
No, ma'am. Well, I don't.
Thank you for your
Rest of
time,
the
and thank
board.
y'all for your,
All right, thank you, ma'am. Does the applicant want to speak, the owner or applicant?
he doesn't own it yet.
You're right, I had to correct myself there.
And Mr. Champion is up in age, so.
Right, okay, all right. At the point now, we need to, yes,
Close the public.
motion to close the open session.
I'll make a motion to close.
Need a second?
I second that.
Second. All right, all in favor, raised hand. Okay, all in favor, we're in closed, session has been closed. Mr. Allen?
Okay, so this is a little bit of a unique situation, as Ms. Donaldson said. It's a large property that fronts Lamar County Line Road and South Walker's Mill. The owner will divide it basically in two, and he will have the portion that fronts Lamar County Line Road. There is a lot of acreage, there is adequate frontage on paper. However, this pond really kind of complicates things, as it pretty much almost cuts the piece in two. You could have a driveway from Lamar County Line Road along the dam of the pond to get back to the property as the map shows. Eva, can you come down to where that said, like, track 1, track 2? It might be further down from the staff report. Other way. Keep on going. Not that one, keep on. There is. So scroll, yeah, there you go. So it's got home site, 3+ acres, and then another home site below that. Basically, I don't have a concern with one lot on there. However, you could, as I said, you could have the driveway on the pond dam and have enough acreage to have a home site. The problem comes when the applicant wants 2 home sites on there. As Ms. Donaldson said, you can't go to the left of that pond with a driveway. You'd have to share that pond dam for the driveway as well. Shared driveways do exist. They're not a ideal situation. Cases of extreme circumstances, I guess. The problem arises, and you always think this will be me and my family living here forever. Circumstances happen. You could possibly have a situation where 2 strangers own the home site there and they can't stand each other and they have a shared driveway. So that is always a possibility. You could remedy that with an access easement, but again, that's not an ideal situation. So that was my concerns about that. If you had an access easement, and Newton, correct me if I'm wrong, the people that share the easement would have access rights as well as those that, the future owners that had it as long as it was in their deed. So it is doable, but not ideal. So that was my concerns about
The
it.
easement would run with the land.
Right.
And it would be part of the transferable interest in the property. Bottom line is, the pond here is it helps to cause this problem. And what David has said is accurate. It can be done, but it is not ideal. But we know everybody in the future will get along, so we won't have to worry about any issue arising.
Is there a home here already?
Well, we need to get into the,
There is on South Walker's Mill, but that thick red line in the middle there will separate the 46 acres, and the 46 acres has nothing on it.
okay, is that all the additional?
Yes.
Okay. So we need a motion so we can discuss this one. We need a motion to take action, begin taking action. And a motion to approve or deny, or we need to make a motion so we can discuss.
I'll make a motion to follow staff recommendation, to deny this one, so we can talk about it a little bit.
Okay, do we have a second?
Second. with
All
the
in favor?
staff
Raised hand?
to kind of look into
Okay.
it.
No, we can't, let's back up. We actually.
Y'all were gonna
just-
have
we just
discussion.
voted, and we gotta discuss before you
You
vote.
called the vote a
Sorry,
little quick.
sorry, I'm getting ahead of myself. All right, so we got the motion, we've got the second, now we have discussion before we actually vote.
Correct.
So does anybody have comments, discussions?
So currently, so I'm looking at the map here, so currently at 75 acres, that red line is part of this parcel currently?
Yeah, if you get rid of the red line there, the very weird shaped property is almost shaped like I don't know what it's shaped like. Anyway, it fronts South Walker's Mill, a trapezoid.
I know I can't bring, I'm known like all of y'all's things, but I do have better pictures if you need some overhead aerial shots.
Yeah,
Right.
no, we've got some, man.
So the house, there's a existing house that fronts South Walker's Mill. But the property again will be divided in half. 46 acres to the right will go to this new owner, and there, in the bottom right corner of the screen, their land will front Lamar County Line Road.
So. So who are we sharing a driveway with is what I'm trying to figure out.
He wants to build a house back there where it says home site 3+ acres, and that's fine. He can do that with a driveway going over the pond dam. The problem arises when he wants a second home site just below that from that label. The two houses, if built, would have to share a drive along that pond dam before they branched out.
There's no homes on that 46 acres?
No, not right now.
The property has not been purchased at this time.
Oh.
Yeah. I guess, yeah, it's difficult. I mean, I own, a fairly large tract of property myself, so I understand, wanting to be able to move this large tract of property. But, doing this larger piece with this one drive it's just gonna cause complications for the owners down the road. Either they may not get along, or it's gonna impact how much they can get for their property versus what they paid for it, and sellability in the future. So just I can just see a lot of problem sets that I just can't say yes to put somebody in those situations down the road, so.
I think we need to table it to get some more discussion, look into it more. Table it for right now until we can get back into it.
Yeah, well, we've already made a motion
Yeah,
to
motion,
deny
Right.
it, so.
I think at this point, I'm with you. I mean, David said it best. I mean, or Newton, it always starts off innocent enough, but you got two houses, or you have a loved one living beside you, and eventually, whether we sell or not, eventually people die. And those houses end up with other people, and it just creates complications in the future.
Yeah.
It's just drawn up weird too. It's just not really making sense to me.
Either, to be honest with you.
The last time we had a subdivision that had a lake problem was a minor subdivision on Hamill Road. One lot was approved, was not an issue, but it was not for multiple lots. It wasn't for 2 or 3 lots. It was 2 folks next door sharing a driveway by means of an easement because the lake blocked access to one. But it was one lot.
Does anybody have any further discussion? If not, we're at the point to vote on the motion in the second. So everyone opposed to the motion of denying this application, raised hand.
Opposed to the motion or in
Well,
agreement
no,
with the
no,
motion?
in agreement to deny, sorry. I just double negative myself. Okay, so to approve the motion, raised hand. Is Mr. Park, okay, all right.
Approving
so
a denial motion.
Yes.
Correct.
We're approving the motion to deny,
It passed.
yes, to clarify. All right, thank you. Okay, moving on to item 7. Mr. Allen?
Okay, application 25-04V, Spalding Stonebriar LLC, owner Lot 9, Quarry Circle, Stonebriar subdivision, Griffin, Georgia 30224. Parent parcel is 233-06004, located in land lot 88 of the 2nd Land District, requesting reduction in the front yard setback of a residential lot. So this was first discussed and heard back in April, I believe, with this board. At that time, the new developer, who is here in the front row this evening, was going to discuss some improvements to existing phases, with the neighborhood. That's still kind of ongoing right now. But anyway, there was a lot more variances back then with corner lots in addition to these two lots you have tonight. Those I think will be resolved because will basically be the same as phase two. However, you do have this item I just read on Quarry Circle. It is a cul-de-sac lot, and the bulb, yes, it's a technical term, of the cul-de-sac dips into the lot where it hampers your ability to have a big enough house. Eva, I think there's a drawing at the very end. Try to get past all my fluff here. One more is a blow up of it. Yeah, there we go. So with the cul-de-sac curving out like that, it shows what the existing 50-foot setback would do to that square, that dashed line there. They're proposing a 30-foot building setback to make that footprint of the house possible. So that's where we are with this, just focusing on this item and the next item with another cul-de-sac, trying to improve the depth of the lot due to that cul-de-sac bowing out like it does.
Is that, okay. Are we able to combine 7 and 8 together and have one public hearing?
I don't have a problem with it, but
Because these are variances, I think you're better served
Separate?
to do them separately. If this was part of another development where we could put them all together into truly one hearing, but each variance is gonna have to stand on its own.
All right. We need a motion to open public hearing at this point.
Make a motion to open.
Second. All in favor, raised hand. We're in open session at this point. Ms. Down.
Mr. Chair, we have 3 people signed up. First speaker is Gary Farron. I'm sorry, my apologies.
Call me whatever. Hi, I'm Gary Furrow. I live at 4355 Thomaston Highway, Woodland, Georgia, and that's not in Spalding County, it's in Talbot. But, the project is Stonebriar subdivision, phase 3 and 4. The particular the lot we're talking about, we could build a house on it. It would just be an oddly shaped house. It would only be 35 feet deep, and we could put a house on it. It would just be 2 stories and really kind of fill up the lot. So we're asking for some help to do a deeper lot, so you'll have a little bit more side yard between the 2 houses. So that's really the request for both of them. The other 120 whatever odd houses, that they're fine. We can live within the rules. We're just asking for a little hardship variance on that, at least 20 feet, so we could do a 50-foot deep house. And that's for each one, and that allows us to have a couple of different options of houses. So, I'll reserve my time for any other things, but that's in a nutshell. We need another 20 feet to do houses that are consistent with the rest of the subdivision in phase 1 and 2 and what we plan for phase 3 and 4. So just those 2, they'd be a little bit different and harder to sell, I think. So.
Thank you.
Thank you.
Mr. Chair, the next speaker to sign up is Joseph Araya. Okay, thank you. Next speaker is Joel Paz. Okay,
Sorry.
thank you.
Is that all this? Okay. Those are all the speakers we have for this one. Need a motion to close.
Close.
Second.
Second.
All in favor, raised hand to close the session. Okay. All in favor, Open session is closed. You have additional information, Mr. Allen?
No, sir, I had recommended it for approval since it's just one lot on this cul-de-sac, and then the preceding item is a single lot on another cul-de-sac as well. It would just give them more breathing room with the setback of it, the setback variance if it was approved.
At this point, we need a motion, so we can move forward and discuss. Need a motion to either approve or deny.
I will make a motion to move into discussion, but I'll make a motion that we approve with staff recommendations.
We have a second.
I second that.
All in favor?
Let's
Raise-
go into discussion first, or do we vote now?
No.
Discussion.
Discussion.
Right, thank you.
We're pushing it forward. Thank you. So yes, we're moving to discussion now.
So none of these roads have been cut in yet at all?
No.
This is completely new development?
Phase 1, Phase 2 are done, been there for a while. Phase 3 and 4 are a field right now.
Okay.
I guess from my point of view, and everything I say is motivated toward continuing to move Spalding County in a positive direction and establishing communities that are good for residents, that make residents feel good about living where they live. This is already a high-density development, and this is a subpar lot that they're requesting, because it's too small, they're requesting the setback be decreased. To me, I feel that it more benefit the community better if that small lot was absorbed into two adjoining lots to make the development more appealing and more livable for the residents. So, just my input.
So,
How close are the houses out there? They right up on one another with this?
Can you bring up the map that shows
How
the
close
dimensions
are
of
the
the
houses?
lots?
there's a,
The overall,
Subdivision plat.
It's like,
Yeah, just the dimension of those lots.
okay.
Right there.
if you don't mind, I
Can,
wanna see that too.
can you blow that up some?
Sorry about
So that's Phase 3, I believe.
What,
so we're down here now is what we're
Okay.
looking at. But that's what's, so Quarry Circle's actually gonna extend around.
I don't see dimensions on this one.
So that's what's currently up.
If I remember right, I think they were like 50 feet wide. Is that?
and the offset home he's trying to build, it's gonna be down here.
It's gonna be similar to like this,
Okay.
right? It's really what,
Yeah, I see some 75s there.
So what did we do in phase 1 and 2? I mean, how do we address those in phase 1 or 2? Were there variances on those houses, or did they move them back, or bigger lots, or?
Phase 1 and 2 were developed in 2002. And it would have been, Adam, it would be whatever is shown on the plat that was approved at that time. Now, that subdivision has, so you'll know a little bit of history on this, that subdivision has had issues in Phase 1 and 2, principally tied to the developer going into foreclosure in the recession of 2008 and thereafter. This was started and intended to be a very nice subdivision with common space and playgrounds and so forth and so on. And it has suffered from the fact that when the developer went into foreclosure, those things were not covered, those things were not handled by an HOA that was in place because their development had not gotten to the point for the HOA at that time. So for example, we have people who have bought the green space lots in Stonebriar who believe they should be able to build on them, even though the green space is preserved in the rezoning ordinance that was done for the subdivision. So, what we had hoped was that when Mr. Farrow came in and they were doing phase 3, and I might add, we contacted former Commissioner Johnson, who lives in that subdivision, who was very anxious to work with y'all to try to get.
Developer,
Pardon me?
same developer, or different developer?
Different.
that did it?
Different. She's in phase 1 or 2. I couldn't tell you which one she was in. But she was very hopeful that the development of 3 could be worked with Mr. Farrow to be able to get improvement in the entire subdivision. And I might add that Mr. Farrow at the last meeting, y'all may remember, expressed some concern about the condition of some of the area in phase 1 and 2. So, but that's the nature of the subdivision, and that's a little bit of the history. That
So-
developer had 2 subdivisions that went into foreclosure they continue to be issues today.
So it currently
Because
does
of the
not have the
foreclosure.
green space that was slotted for it, is
Pardon me?
that? So currently it does not have the green space that was slotted for it, is that correct?
No, what happened was because they thought nobody was paying attention, somebody in the lots that were supposed to be green space were sold at a tax sale. And so somebody went in and bought the lots that are green space and then thought nobody would be looking, came to the development office. I think you had somebody as late as last month that came in. They come in with successive community development directors to see if they can get them a permit. But thus far, it's been caught, and the tax sale acquisition has caused them more problems than they had expected, because they don't have development rights on that because of it being preserved as green space.
So I guess I view our position as being able to provide something better for the residents of Spalding County. And I can't approve this and feel like that I'm providing something positive for someone that's gonna live on that lot that's too small, so.
They're too small, I think.
So at this point, the motion has been made to approve.
So we vote on that motion, or can I withdraw my motion?
You can, Adam, you can withdraw your motion and Ms. McCord would withdraw her second.
Withdraw my motion.
I'm gonna withdraw mine.
So both motions have been withdrawn, so now we need another motion.
I will make a motion to deny the variance request.
Second,
I second that.
all in favor, raised hand. Motion approved, 4-0. Okay, Mr. Allen.
All right.
We're moving on to number 8.
Application 2507V, Spalding Stonebriar LLC, owner, Lot 37, Boulder Court, Stonebriar Subdivision, Griffin, Georgia, 30224. Parent parcel 233-06004, located in land lot 88 of the second land district, requesting reduction in the front yard setback of a residential lot. Again, same situation on a cul-de-sac, different street, same subdivision.
Need a motion to open the public session.
Motion open.
Second,
I second it.
all right, all in favor, raised hand. All right, we are now in public session.
Mr. Chair, our first speaker is Mr. Gary Farrow.
So I did want to make a slight clarification that the lots themselves are in fact legal lots. We can still build on them, just without the 50-foot, with a 50-foot setback. We will in fact build inferior houses to the ones we're proposing. So if you like that, that is fine. But I don't think you're precisely understanding what I'm asking. We are going to build a house that is 2 stories, that has a smaller footprint, but will basically still comply with your rules. But the one that we're attempting to build will be a ranch style house that has a little bit deeper and will be more consistent with the rest of the subdivision. We're still going to build a house on it, just not the house we want to build. It is a geometry problem. The square footage of the houses, of the lots are the same. It's just that we can't build in a certain area. And so, I mean, it doesn't really matter, except you'll have 2 houses that are inconsistent with the rest. That is the problem for us. We can build either house. It won't keep us from building it. So I just wanted to make that clarification.
Mr. Chair, the next speaker to sign up, Mr. Joseph Raya, did you want to speak on behalf of this one? Okay. And Joel Paz? Thank you. There's no more speakers signed up.
Okay, need a motion to close the open session?
Motion to close?
Second?
Second.
Okay, all in favor, raise hand. All in favor, open session is closed. Have any additional?
No, sir, I don't.
Okay,
I'll make a motion to deny.
Second that motion.
okay, all in favor, raise hand.
Let's go into discussion
Oh,
first.
sorry,
You gotta discuss first.
discussion. Does anybody have any discussion?
I would just like to make the point at this point that Mr. Farrow has made the statement that he's gonna build inferior homes. So community development may wanna take that into consideration when reviewing these building permits. So I would like to make that point there, since that is on the record.
I guess I'd like to make the statement too, is that, and I realize, you know, that you're gonna utilize the lots. But part of this stance is Spalding County, we as a whole are trying to improve and move forward in a positive manner. And unless we start taking some steps and stances in that direction, we're not gonna make the changes we need to make. So unfortunately, you know, this falls into that category for me, and apparently for the other board members as well. And we're just trying to do justice to our residents moving forward. So that's all it is.
And here's the reality. I mean, none of these roads have been cut in. None of these lots, have these lots already been divided at this point?
On a
For phase
preliminary
3 and 4?
plat, yeah, the lots have been approved on a preliminary plat.
And then, I'm sorry, Alan.
No, you're
Well, then it really boils down to, I forgot about that the lots have not really been established, you know. So it's up to the builder's decision whether they're gonna,
There's plenty of alternatives.
yeah, there are additional alternatives rather than saying we're gonna build on a smaller lot. But, okay, any
You
further?
wanna crowd the houses so close, you know, subdivision, you want it to look nice and you start building, you know, that's gonna take away from the value of the people that's already out there. That's
Right.
what
I agree. Any further discussion? Okay, need to take a vote. All in favor of the motion to deny the application, raised hand. 4-0, unanimous, 4. Okay, Mr. Allen. We're moving on to number 9 now, Mr. Allen.
Okay, last but not least, application 25-01 APP 4026 North Expressway LLC, owner 4026 North Expressway, Hampton, Georgia 30228, parcel number 500-05022, located in land lot 107 of the 3rd Land District, is requesting an appeal of a decision by the administrative officer per section 410 of the zoning ordinance relating to the continuance of a scrap recycling business on the subject property.
Mr. Chairman, this is gonna take a little bit of time to set up. We might take a 5-minute break and or 10-minute break. This is gonna take a little bit of time, I suspect, may not, but give us time to set up.
Okay, so under the guidance of our attorney, we're going to take a 5-minute break. And so we'll be back at 7:15. Yes, sir.
application for the hearing, make the,
You want me to read it? Is that what you're saying, or?
have David call it the,
Read the item.
Yes.
read the item on
Yes,
the
read
agenda.
the,
I'm sorry if I wasn't saying it very.
Application 25-01 APP 4026 North Expressway LLC, owner 4026 North Expressway, Hampton, Georgia 30228. Parcel number 500050022, located in land lot 107 of the Third Land District, is requesting an appeal of a decision by the administrative officer for section 410 of the zoning ordinance relating to the continuance of a scrap recycling business on the subject property.
I'm gonna speak to you first in order to explain what this application is about briefly, and then explain to you the procedure that's required, because we don't have these appeals very often. However, if David's office takes an action and the person, for example, who is a permit applicant, business license applicant, whatever his office is in charge of, if they believe what he did or his office did is improper, then they have the right under section 410 of the zoning ordinance to appeal to this board. That might be why you're called the Board of Appeals. Now, this is very different from what the Planning Commission does when they exercise recommending authority over rezonings or over special exception conditional use applications, or a variance that is part of a rezoning. So, this application, filed by Mr. Bacon's company, asks this commission, asks this board to consider what David did, find that it is in error, and direct David to do or modify what his position was earlier. And in this case, this pertains to, among other things, a business license. Now, let me go through a little bit of legalese. You are sitting here essentially as an administrative judicial body. In fact, you are specifically known as a quasi-judicial body when you're sitting in this capacity. So, as opposed to the hearings that you've conducted on the variances that you've heard, this is in fact deemed to be a full hearing. So, we will treat this as if it is an administrative hearing and comply with the requirements that the law has for an administrative hearing. Now, what that means is you will take testimony from the witnesses here. We're gonna, Mr. Slaughter as chairman is going to administer an oath similar to what would be given to a witness in court. And we will have testimony from Mr. Bacon as the applicant for his companies, and then from staff. The reason we do this is because under the rules that govern county actions, David is deemed to have acted properly until it is proven otherwise. So when an appeal is taken, the applicant for the appeal has the burden to show that David's actions didn't comport with either the ordinance, the statute, or the law, or whatever the standard is. Now, to that end, excuse me, to that end, you will actually have evidence to look at tonight. And we won't have cross-examination of witnesses. We're not going to go through like a full hearing, a full formal hearing. This is going to be like an administrative hearing, but you are required to take evidence on this and you are required to treat it as an administrative hearing in order to comply with the requirements of a new zoning statute, House Bill 1405, that sets and identifies this as a quasi-judicial proceeding. So, Mr. Chairman, with your permission, I have tendered and presented to y'all a packet called Documentary Evidence. And I'm going to address the first parts of these that deal with legal documents and documents that just identify the property and identify the parties and identify the prior action that has occurred leading to the appeal. So, if you would, take that now, and I'm going to walk through exhibits 1 through 20, just to let you know what they are. Then I'm going to ask Mr. Slaughter to accept those into evidence. These are documents that are part of the public record. And also Exhibit 23. All right. But first, we were going to go through and follow a procedure. I sent a memo out this morning. Mr. Bacon's represented by Steve Rothman in Atlanta, who is on a flight back from Europe. So Mr. Bacon will be presenting for himself as the applicant on the appeal. Then when he is through, we will come back and tender these documents. Some of them are documents that Mr. Rothman had requested that he would present, and we had no problem with having those come on into a record even though he was not here. But that's the procedure. Mr. Bacon will present the case on behalf of the appeal. The county will respond, and Mr. Bacon will have the ability to rebut because he has the burden of proof. So having walked through that procedure, I'm going to sit down. I will go through the evidence, the documentaries evidence that I referenced just then when it's time for the county to proceed with its portion. Okay, thank you.
Thank you.
So, Mr. Chairman, it's time to ask Mr. Bacon to come and present his case.
So he goes first.
Yes,
Okay.
yes.
Mr. Bacon?
Yep.
Now, do we swear in now?
Swear him in now.
Okay, Mr. Bacon, the information you're presenting, is this the truth and the whole truth, so help you God?
It is.
Okay.
So we purchased the 4026 North Expressway Parkway as part of a scrap deal. It was previously a forklift salvage operation for 30 years or so. And the guy that owned it died of an overdose, and his mom called us, and we went and cleaned it up and bought the property as part of the cleanup. And we operate bare metals over here off Kalamazoo, and we did operate a location there open to the public for about 2 years. The deal we made when there was a Sunnyside was we could keep operating under that grandfathered status if we built a fence, planted some plants, and painted a few containers. You'll see if you look through this that we did some of that in the time that was allotted, but not all of it. We had an area where they did not build the fence to height, and we had another area where they didn't paint some of the containers. And that is what has us here today, is our guys didn't get the fence built at the right height in an area and didn't paint some of the containers in time when he came back out to inspect. And that was the reason. Today we're using the site for repairs, maintenance. We'd like to maintain the grandfathered status. It doesn't make sense for us to operate there, today, just competitively. It was not a money-making location, and we don't really have any immediate plans to open it back up to the public, but just to help preserve the value of the property for whatever may come in the future, we would, just ask that you would allow us to keep our grandfathered status. And, we've fixed the fence and painted the containers, and, that's where it's at. We just didn't get done what we said we'd get done in the amount of time we'd said it'd get done. And, he's not wrong. That's the deal we made, and we didn't finish it in time, and that's on us. And so correct me if I'm wrong, but is that sort of, or I guess maybe I can't ask you all questions, but yeah, that's sort of the, I don't know. You did a lot of talking. I was a little confused there at the end. So, but
I get paid by the word.
Yeah. So, I'm just here asking, if, we can keep what we had, and, I'm sorry for not getting it right. So.
Straightforward enough. Thanks, sir.
Let's walk through your documents.
They just swear you in, dude.
And you can, I swear I'll tell the truth, the whole truth, nothing but the truth, so help me God, as it applies to these documents, because that's all I know about this.
All right.
All right. I want to walk through with you the documentary evidence that leads to this. First is Exhibit 1. Now, please note that your documents are printed on front and back. All right. Exhibit number 1 is the Q Public Tax Assessor's data. This is a public record, and you can see pictures of the facility, and you can see the description of the property. You can also, and we will go, the other documents will identify this, but it will also go through the ownership history of the property. All right. And Mr. Bacon's correct. This property was known affectionately in the Community Development Office as the Forklift Graveyard. All right. Now, move to Exhibit 2. You can see the location of the property on the North Expressway. Again, this is a public record in Q Public. If you move to Exhibit 3, there are several corporate entities that have been involved with the ownership of the property. Mr. Allen will go through that in a little more. But we have pulled the corporate organization documents from the Secretary of State related to them. The first is ALS2 LLC. This, you'll see how this plays into the ownership later. Then Exhibit 4 is the annual registration for ALS2 LLC, and it is currently in good standing with the Secretary of State. Exhibit number 5 is the amended annual registration, and that was done after ALS2 LLC was created, and they did a minor change, but that is the amended annual registration that they have. And as I said, they are in, the records of the Secretary of State show that they are in compliance. Excuse me, let's move to Exhibit 6, which is a certificate of organization for 4026 North Expressway LLC. This is another company that's involved with the property up there, and another company in which Mr. Bacon is involved. Excuse me. All right, then you will also, and that covers the articles of organization, and you will also see that the registration is, their annual registration is shown on Exhibit 7, and it is in good standing, just like the others, or the other one. All right, let's look to Exhibit 8. This is another public record. This is the limited warranty deed by which Eagle Sunnyside Properties LLC conveyed the property to ALS2 on May 23rd, 2019. Eagle Sunnyside would have been the owner and operator of the Forklift Graveyard at the time, in 2019, at the time of its purchase. That document takes up several pages, and it appears that it was, the transfer of that property was part of several properties that were transferred to Mr. Bacon's company. Oh, excuse me a minute, let me get some more. Exhibit number 9, they executed another deed the same day, assume it's issues related to title, but exhibit number 9 is a quitclaim deed from the same entity, Eagle Sunnyside Properties LLC to ALS 2. Exhibit number 10, ALS 2 conveyed the property to another entity owned by Mr. Bacon, 4026 North Expressway LLC, which is another Georgia limited liability company, and you can see that occurred in April of 2022. So the property is presently titled in 4026 North Expressway. It was first acquired in ALS 2 LLC, but the title is now in 4026 North Expressway. Now, there were some operation issues at the site, and in exhibit number 11, you're going to see another public record, which is a consent order entered in February of 22. The property was cited for several conditions and in 2 different citations. If you will look at Exhibit A to the order, consent order, you can see the citations were citation 21-COV-022 for illegal burning, and then citation 21-COV-0021, which was a zoning violation. And the parties, both the City of Sunnyside, Spalding County, and the property owner were able to reach an agreement on resolving the citations, and this document you're looking at is the approval of that by the magistrate court. However, if you will look at Section 2, it identifies the obligations that ALS had to construct a privacy fence, to install vegetative screening, landscaping pursuant to a plan. The plan is attached to this order. And to do a privacy fence, and in consultation with folks who lived around there, there was an agreement to permanently place shipping containers for additional privacy and sound protection of adjoining properties. But there was also an aesthetic requirement to have them painted and be in a consistent dark color rather than just boxes, metal boxes sitting out there. Yes.
The illegal burning was torch cutting operations for the forklift removal. I just want you guys to know we weren't just like setting stuff on fire. We were using torches to cut them down to sell them, and it was creating smoke, and we couldn't do that. We found out, but I just didn't want to.
Yeah, if you would, if you hold any rebuttals to the end of when Mr. Galloway is finished.
By the time this came up, the illegal burning had stopped, and you'll see the reference to it because y'all agreed to stop it. Okay. Now, because this involves action under our zoning ordinance, and one word of explanation, at the time all of this arose, the property was divided between the City of Sunnyside and Spalding County. And we're going to see that in a second, but it is now governed by the Spalding County zoning ordinance. So, if you will look at Exhibit 12, Exhibit 12 is Section 106 of our Uniform Development Ordinance. So this is what Mr. Rothman, as counsel for the applicant, asked to be put into the record. These are our codes, and you can see it includes our Uniform Development Standards that include all of our international codes, and also Section B consists of the ordinances that are appendices to the zoning ordinance. And by agreement of council, those will be tendered into the record. Section 403 is Exhibit 13, and 403 deals with nonconforming uses. The reason that is applicable here, as Mr. Allen will explain, is because the property was zoned C1 under both Sunnyside and Spalding County ordinances for the respective portions, and recycling center was not allowed there as a permitted use, but because the forklift graveyard had been there for so long, it was a non-conforming use. And so this 403 addresses non-conforming uses. Section 403 was superseded by the document at Exhibit 14. And in 2023, Spalding County had to adopt new ordinances related to the implementation of House Bill 1405 dealing with zoning. And at the same time, we revised our procedures dealing with the continuance of nonconforming lots, uses, and structures. And this is the ordinance that governs that. This ordinance is available on Muni Code. It is a public record, but it has not yet been codified after 2 years. You have to know where to look in order to find the uncodified ordinance. But you can see that was adopted on June 22nd, 2023. Exhibit 15, this is Mr. Rothman requested that we include in the evidentiary material the Article 23, which governs the official zoning map of Spalding County. Exhibit 16 is Appendix C of the zoning ordinance, and this is your enabling legislation as a Board of Appeals, and it documents how you function, what your purposes, what you can do, what you can't do, and how you are to make your decisions. Again, that is by consent. And then finally, Exhibit 17 is your Section 410, which is the authority for you to deal with an appeal of an action of the administrative officer or the building official. This sets out your authority to be able to hear the appeal. All right, and if just for everybody's knowledge and recitation, Section A is applicable here under 410 if the administrative officer, that's Mr. Allen, or building official executes an action which the aggrieved party believes to be contrary to the ordinance. That action may be appealed. Such appeal must be filed within 30 days of the date on which the action by the administrative officer or building official was taken. And Mr. Bacon's counsel filed the appeal within that period of time, so it's properly before you. Now, one other section we have to go through is Exhibit 18. In 2024, the city of Sunnyside terminated its charter. The city is created by local legislation by the legislature, and the legislative delegation for Spalding County, working with the city, introduced House Bill 542, which terminated the city of Sunnyside's charter. And under House Bill 542, all of Sunnyside's functions are now within the jurisdiction of Spalding County, and that includes the zoning applicable to property within the city. And pursuant to that authority, Spalding County in spring of '24 began to adopt provisions to get property in Sunnyside zoned under the Spalding County ordinance. If you look at Exhibit 19, this is a memo we prepared for the county, which set out the procedures for dealing with parcels located entirely within the city of Sunnyside, but also it set out a procedure governing split-zoned parcels, which means, as this parcel was, part of it was in Sunnyside, part of it was in Spalding County. So, what happened with those parcels is that, if you look now to Exhibit 20, on May 23rd, 2024, I'm sorry, I made a mistake. The legislation was passed in '23. I'm sorry. But the charter terminated December 31st of '23. So then we had to do all of this work in '24. Sorry, I got my years wrong. But in exhibit number 20, these are the minutes from the Spalding County Board of Commissioners meeting in which the parcels that were in Sunnyside were rezoned. And if you will look at section 16, application 24-25Z, that pertains to the property at 4026 North Expressway. And it rezoned it to C1 Highway Commercial. And it is also now governed by an overlay called the North Expressway Improvement District. So the property zoning stayed the same. It just transferred jurisdictions. Now, the last one, the last exhibit I would like for you to look at, I would like for you to skip 2 and go to exhibit 23. There's another entity that's involved, and this is the Certificate of Organization for ALS Operating LLC. And ALS Operating LLC is an applicant on, as Mr. Allen will advise you on the business licenses that are pending. So, Mr. Chairman, I would ask that you accept into evidence exhibits 1 through 20 and exhibit 23. This concludes all of the public records that need to be part of the record in order for you to have information on which you can make a decision on the appeal.
Thank you, Mr. Galloway.
And now I've put everybody to sleep. I will ask Mr. Fletcher to come up with code enforcement, and he will be the first fact witness on behalf of the county.
Fletcher, just announce your name and title and.
My name is Luke Fletcher, and I am the Director of Spalding County Code Enforcement. Do I need to be sworn in?
I swear, man.
Yes.
Okay, all right. The information you're presenting, is this the truth and the whole truth, so help you God?
It is.
Okay.
All right, I was asked to speak tonight in reference to the things I've observed at 4026 North Expressway over the last year plus. In June, I took this position, the Director of Code Enforcement, in April of 2024. In June of 2024, I was contacted by the Director of Community Development at that time, who was Sylvia Reddick, in reference to checking for compliance with the consent order that was issued for 4026 North Expressway in Spalding County. Ms. Reddick also provided me with a copy of that consent order, which has been submitted as evidence and labeled as Exhibit 11. I responded up to 4026 and looked at the location, but I had questions regarding, at that time, regarding 2B of Exhibit 11, which addresses the landscaping, and could only provide an update as to what I observed at that time, as I had no prior knowledge of the condition of the property and other requirements. In front of you, you should have Exhibit 21 also, which I need to submit that or introduce that as evidence, which I'm asking.
Sorry. Newton, is it okay if we ask some questions as we're,
You can ask questions at any time.
okay. June 2024, when you visited, was the vegetation complete at that time?
Okay, yes, I will address that.
Okay, so you get into
yeah,
that. Okay.
Yeah, I will address that, but yes,
All
it was. So at this time, I would like to submit into evidence Exhibit 21, which you all should have in your binders, which includes photographs taken at various times throughout our investigation. On July 11th of 2024, Ms. Reddick requested that I visit the location with her to research what, if any, items on the consent order had been completed. So we did respond together and later determined that the landscaping along the west side of the parcel, or the North Expressway frontage, had been completed and was in compliance with the consent order. On this date, we also observed some of the privacy fencing had been installed along the east side of the parcel, which would be the back side or Old Atlanta Road side. And also there were numerous containers just kind of scattered about the property. The containers had not been placed along the property lines as indicated, and were not painted a consistent dark color as required in the order. On numerous other occasions, between July and December of 2024, I rode by the location and found it to remain in the same or similar condition as found in July of 2024. Mid-December of 2024, I completed another check of the location from Mr. Allen, who had become involved with the matter after he had taken over as the Community Development Director. I reported back to Mr. Allen at that time that the property remained in a similar state with no additional fencing installed and the containers not being painted and placed as required by the consent order. On January 2nd of 2025, I again visited the property to check for compliance with the consent order. On this visit, I observed the following conditions. In reference to the consent order 2A regarding the fencing, there had been some effort made regarding the fencing requirement in this section of the order. However, it was found that along the south side of the parcel, the fencing installed from the area of the scale house to the end of that section was reduced to approximately 6 feet in height, of course varied as ground level changed, and did not meet the requirements established of constructing an 8-foot privacy fence. Section 2B landscaping, as I stated earlier, this requirement was completed prior to my initial visit and was in compliance. Section 2C regarding the containers, the placement of containers painted a consistent dark color along the privacy fencing on the ALS side of the fence was not in compliance. No efforts were observed during the months of me monitoring the location to come into compliance with this section of the order. During the time I monitored this location, I did not observe or find any evidence of business being conducted on the property.
What time frame would that be?
That was from June to January 2nd. I also observed little effort placed on gaining compliance with the consent order issued, and the property remained out of compliance at the time of our first scheduled meeting on May 15th of 2025.
was there any contact with anybody at the business when you were going out, or were you just going out, or were you actually speaking with someone?
There was no one at the business, at all of my visits. One of my officers did have contact with an individual, who was working in the shop on one visit. But no evidence of actual business taking place. They were just doing some work on the property.
What day was that? Would that have been?
That would have been October to November timeframe that
20,
one of my
24.
officers went out and had contact with an individual.
And during this, David, were you in contact with Mr. Bacon or anyone at this time either? Like,
David's going
oh,
to
okay.
speak.
My bad.
I know this is a little more formal than we're used to, but
Yes, sir. Is that all you have?
That's all I have.
Okay, so on May the 15th, the fence and containers had not been completed to standard, is that?
They were still not in compliance.
And when was your last visit there, or the last from code enforcement?
Official visit was May 15th. Of course, we do ride through that area pretty consistently, and I still have not seen effort to gain compliance.
Okay. And as far as no work activity being conducted on your visits, that was noticed on from June of 2024 through January the 2nd this year, is that correct?
And I still have not observed any actual business taking place. Now, there has been vehicles on site, but as far as
But no
business,
activity as
no
far as
business
actually
taking
conducting
place.
business is what they should be.
Right.
What about before June of 2024? Any,
I am not familiar with anything prior to June. It was my first,
okay,
contact with the business.
all right, thanks, sir. Or do anybody else have questions? Okay. All right, thanks, sir.
Yes, sir.
Alan,
Okay.
you gotta do it from there?
Yes.
Okay, so.
swear him in.
Swear you in. The information you're about to, provide, is it the truth and the whole truth, so help you God?
Yes. Okay, so I came along in August of 2024 as the director. Prior to that was the occurrence of the city of Sunnyside ceasing to exist in early 2024. Mr. Bacon is correct. They had an agreement in the city of Sunnyside then. Of course, then it became Spalding County land. Before my time in the spring of 2024, and in your packet on your exhibits there is all the city of Sunnyside businesses that were coming into the county were issued a business license at that time, back in the spring of 2024. So that was on record before I got there. When I got there in August and through September, I was made aware of the situation with the property and Mr. Bacon and his company there, and the fact that the consent order was still ongoing, the requirements for that, for the fencing, landscaping, and containers. I was made aware of the fact through code enforcement that it was not complete, and we are coming into fall. The fall is always business license renewal time, so we came into that, and I wanted to address this with them so there wasn't going to be a holdup on the 2025 business license renewal. So I did send them a letter on September 11th. I'm sorry. Yes, it was in September of that last year where I outlined to Mr. Bacon what was deficient still with the 3 things he had to do on the consent order. And I gave him an extension of the deadline to complete these by December 31st of 2024. I, like Mr. Fletcher, checked it from time to time that fall, did not see any real activity till sometime in December. then the December 31st deadline passed. I got Mr. Fletcher to go out there the day after New Year's on January 2nd, as he said, to take photos, and it was documented that, as he said, the landscaping had already been complete, but there is the fence, while mostly finished, there was a height discrepancy. And then the biggest non-finish was not only the painting of the containers, but there was, per the consent order wording, the containers were to be along the fence. And there was gaps, and I have that in my packet of pictures, where there was no containers in certain spots where they should be along the fence, and they were unpainted. So by that time, I contacted Mr. Bacon based on that, and told him I would not be renewing or approving a business license for his scrap recycling business there at 4026 North Expressway. So that is the action that is being appealed.
So these, I'm sorry, so these pictures were taken January of this year, is that correct?
Yes, sir. I would like to bring your attention to part of the consent order. There's a section 5 there, which says, upon continued and ongoing compliance with the requirements of section 2 by ALS, Sunnyside and Spalding County, will not challenge the right of ALS to conduct a recycling facility on the subject property as a pre-existing non-conforming use. Sunnyside and Spalding County reserve the right to issue citation should the future use of the subject property change and such use be in violation of it. So, the fact that they did not fully comply with the agreement, i.e. the fence, the containers, the landscaping by the deadline set, meant that we had now had the right, in my view, to challenge their existence there, to be a use there for what they had previously done it for. There is another aspect of this. You can challenge the right of them as a non-conforming use by the consent order, but you can also do it by our own code, as Mr. Galloway said, the non-conforming use section, section 403, where it states in there that any use that ceases to be active for a period over 12 months can be now considered non-conforming and not legal to do. Per an email back in September of 2024 with a secretary there at the business, we confirmed through her that there had probably not been activity there related, official activity regarding that particular kind of business since summer of 2023, possibly spring of 2023. So that was their own wording in the email. I do have some printouts there from the website Bare Metals, which lists all their locations. The one for 4026 is temporarily unavailable or temporarily non-operational. So based on that evidence, I think there's compelling enough evidence that there has not been official business activity on that property for longer than 12 months. So that is another aspect of why this is no longer considered a legal non-conforming use.
That complete your findings?
For now,
Mr.
yes.
Allen? Yeah. I guess this time,
The only thing I would like to do is follow up and have you accept into evidence. Well, let me, David, identify your staff report on this first.
Okay. In a staff report for this hearing, which was originally in May, I did recommend denial of this continuing to be an operational use with an active business license at this location. Repeal -25-01 APP.
And just to follow up on that, we would ask you accept into evidence exhibits 21, 24, which is the email from the operations person in Mr. Bacon's business. Exhibit 25, which is Mr. Allen's letter concerning the 2025 business license, and 26 46 is the community development staff report, so we'd like to have those tendered into the record as
I was just looking at this email right quick, so it's basically this person at the business saying that they had not operated since spring of twenty. But that, this. I was
Exhibit
asking Mr.
25,
I
I'm
was asking
sorry,
Mr. Allen.
24.
That's from the secretary of the office that I don't know how she got involved.
Yes, we do accept these items into, yes.
And if you, now that concludes what the county has, and Mr. Bacon's able to, time for rebuttal.
Yep, Mr. Bacon?
Yep, so the fence is 8 feet in the area where the guys that put it in got lazy and didn't put it up to 8 feet, so that's been repaired. The conversation and the agreement we had with Sunnyside was that it was not that we were gonna put containers along every section of fence, it was that we were going to stack the containers that we had against the existing fence, which we have done. I think there's 4 or 5 containers that the guys still haven't painted, but everything else should be in compliance. We did not get it done in time. That's on us. It should have been done. We had time to do it. They went out there and were honest to do it. I had guys down there and they didn't get it done. And, you know, if we are not operating a commercial, open to the public metal recycling operation there today, and we haven't been for the last year, that is true. We would like the option to keep the use in the future if it ever makes sense for us to do that again. We have another yard in Griffin. We operate these businesses around Atlanta. You know, you guys got me if you want me. You know, it's like there's a whole lot. You know, I mean, I'm here asking. I know we didn't do exactly what we said we were gonna do when we said we were gonna do it, and I'm sorry. And you know, it's not like I can come up here and tell you anything different. You know,
I do appreciate your honesty.
So
Yeah, it is
I just,
very
you know,
commendable
we'll
in
just
this
see if you
day
want
and
me.
age, so.
Newton, is it appropriate for me to ask you questions
Me?
as the county attorney?
Yes, sir.
So,
Understand, I was not involved with the investigation. The only thing I've done tonight is tender the documents that are in the public record. That's
so
all I've done.
essentially what we're doing here tonight though is we're saying that what David did was right or wrong, like he's allowed to do that or not.
That's
So
correct.
we're not sitting here in judgment saying, okay, well, I don't like what David did, so we're gonna go this direction. We're more or less looking at the facts and saying, okay, he acted within his realm of what he can do. Does that make sense what I'm asking?
Yes, you've heard David's discussion about what he directed and the basis for it. And the question before you is, was that proper? Did it comply with the ordinance? Did it comply with the consent order? Was it consistent with the consent order and those things? And you're simply determining whether or not his actions were correct. If his actions are correct, you deny, the appropriate motion is to deny the appeal. If his actions were incorrect, then the appropriate motion is to grant the appeal.
Okay, so
And in
that's the
granting the
decision.
appeal, you are directing David to take action consistent with you determining that something he did was improper.
Okay. So that's the ultimate decision, is we
Right.
approve or disapprove the
In
application.
non-legal terms, did David call it right or not?
And if Mr. Bacon wanted to pursue this in the future with his property, he would have to come back. I guess it'd be a little bit different process than a variance. He would really have to go, through community, through planning and zoning, and then to the Board of Commissioners, and kind of go through the whole process for that property.
As it stands right now, David has made a determination that the business license for a non-conforming use is not appropriate because the use has ceased for more than 12 months.
Right, but we just had to
Now,
focus on,
If Mr. Bacon desires, if y'all uphold that, if Mr. Bacon desires, he can apply to rezone the property to a classification that would allow a recycling center. But that would have to go through Planning Commission, and it would have to go to the Board of Commissioners for approval.
So at this point, we don't open an open session, we just had it. But we
I'm sorry,
still,
William, I couldn't hear you.
we don't go through the motions of opening an open session at this point. We just move into voting on the,
So you've had your hearing. This is not like a zoning hearing on a rezoning or a variance hearing like you conducted.
right,
You notice there's no public comment, okay? That's because the decision here is whether David's action was appropriate. And without casting aspersion on people who comment in zoning hearings, they don't know what occurred. And the evidence has to come from Mr. Bacon, it has to come from David and his staff in code enforcement.
but at this point, to make that decision, we basically vote on
That
this
is correct.
item. Okay, all right, so we're ready to,
So again, the motion is to either
yeah.
deny the appeal or to grant the appeal.
So at this point, for item number 9, recycling center, we need a motion either to approve or.
I'll make a motion to deny the appeal.
Okay.
I'll second that.
I'm gonna make sure we're looking at this right. So the request is to an appeal, okay, got it. All right, so the motion is to deny the appeal. The second, okay, any further discussion?
No.
Okay, we're all good? Okay, so all in favor of the motion to deny by raised hand, 4-0, motion carried to deny.
All right, from here, that concludes your role. If Mr. Bacon and his counsel desire, they have 30 days in which to file an appeal in Superior Court. At least as to the extent of this decision.
Okay.
Okay.
Thank you, Mr. Bacon, for your forthright honesty, and like I say, it's very commendable, so.
So what does that mean?
Still need to close out the
Yeah,
meeting.
we've got to, Mr. Bacon.
Yeah, we got some other
Let's
business.
adjourn. You're okay, you're all right.
I thought we were done.
Let's
No, we have
adjourn.
to,
and
we
then
just
we
got a
can-
couple more things.
Yeah.
That's fine. At this point, we need to consider approval of last month's minutes. Has everyone had a chance to get them? Do we have a motion to approve?
Motion to approve?
Second.
Second.
All right, all in favor of approving, 4-0 approve. And we need a motion to adjourn.
Motion to adjourn?
Second. All in favor, raise hand. All in approval, we are adjourned.